What we're going to talk about is the issues that you face if you've prepared a new web service and want to make it accessible, the legal issues that unfortunately you have to deal with. Now, this is an overhead cost. Like I'm a software developer. This isn't my chosen. Thinking about these issues isn't my chosen way to spend my time. But the lesson of experience is that it costs a lot more time to set a problem right than to avoid a problem. So what are we talking about when we're talking about web services? It's something where there's a web accessible processing. So you're not simply returning data. There may well be data in a database. There may be data provided by the users, and there's some software that processes it. And first of all, I'll present some examples of this and then discuss what the goals are that the legal process hopefully supports. Then it'll be necessary to discuss a bit about what publication is, what the laws are about publishing, to get some context to understand the issues. I'll apply that particularly to what's involved in accepting user data that you publish if your service does that, like for instance the Protein Data Bank. Discuss situations in which you can effectively issue a service unlicensed. It's not impossible, but it achieves only some of the goals that you might have. Discuss what's involved in the processing that your service performs, and then discuss the issues around derived services when other people use your service in a compound service. And then I'll hand over to my colleague Irene Schluender from TMF in Berlin, who'll talk about the legal issues around liability, the situations in which you could find yourself being sued. So as a first example of a web service created by BioMedBridges, there's GenoBridge, which provides mappings between human genes and similar mouse genes. It uses existing data resources, and it consists of some server-side scripts. And then it serves queries. This is a reminder that even the most simple data-driven service, if it's searchable, its quality depends not only on the correctness of the data, but also on the correctness of some software. In fact, GenoBridge involved a lot of processing to assemble the data too, and we'll talk later about the implications of that. BioMedBridges researchers are also working on a shape matching service. If your electron microscope has revealed a blob and you don't know what it is, then you want to search. You can use this service to search for it. It's taken data that was already public. It's using some open source software to process them. It's also created software of its own. And the third example is Bigr-XNAT. It uses some open source data management software. It's modified it for a specific purpose, and it invites depositions, and it also invites people to download their software to make a clone. So there's a variety of different issues there, and a variety of different legal issues to do that effectively. So what are the goals that you're likely to have when you make a web service available? The Research Data Alliance and CODATA have set out some principles on use of research data, which are really pretty good summary also for web services, that you want to make them accessible and usable. You need a fair balance between the interests of your own institution, the users, and people who've supplied data and software to you. Clarity is very important if you want industrial users. Some academic researchers will use your service without spending a lot of time reading the terms and conditions. But the nightmare for a company is that after they've spent 15 years developing a product, Someone says, well, 10 years ago you used my software and some of my data, and therefore I own a part of your intellectual property. They're not likely to use a service to support their research unless they're clear that they're entitled to do so. A big concern in the academic community, and one around which it has strong norms, is attribution, that when you quote someone else's work, when you use words written by someone else, you cite them with a credit, the same with research data that they developed. Now, I'm not going to talk much about that subsequently, because I think that this is something it's best to enforce by community norms rather than by contract. There are all sorts of complicated edge cases, ranging between writing a paper based on one other person's work to writing a paper based on 100,000 other people's work, that I think makes it difficult to trap this in legal language, and I suggest not trying. So, although, as we'll discuss, there are some situations in which it's effective to offer a service unlicensed, in general, you get more impact if your users know what you're allowing them to do. So, to establish the groundwork, let's take a look. What do you do when you publish? If you write a scientific paper and publish it, you make freely available to all the facts that you report. There's no copyright or patent nature. There's no copyright on the ideas that you express either. There may be a patent, you may have patented applications of the ideas, but you can't actually patent a law of nature either. You do have copyright in the way you've expressed it. If you take a creative step as you write it down, then you have copyright in the wording of the paper itself. So let's look at some examples. If you look up a genomic sequence in GenBank, there is no copyright in the return you get. It's formatted in Courier in an entirely formal way with a white space after every 10th base. There's no creative step in that. It's simply reporting a fact of nature. When a curator has annotated it to say this appears to be a kinase, they're taking a creative step, and that annotation is copyright. But if the annotations are made automatically, they've said that they've generated a record saying this is homologous to kinases, then there's no human creative step, and this annotation is probably not copyright. Notoriously, a genetic test for a SNP of clinical relevance can be patented because that's an application of an idea. To take an example from another domain, when a scientist steers the Hubble telescope and then presses a button to take a photograph, then this is a creative step, and it's copyright just like a wedding photograph taken by a wedding photographer. But if someone's programmed the Hubble telescope to step through a sky survey, then probably these images are not copyright. As a matter of fact, copyright is claimed in them. But it's really debatable whether a court would uphold that. So suppose you want to set your data free for anyone to use. In the USA, you can repudiate your copyright and dedicate the work to the public domain. You can't do that in the UK. In the UK, you automatically have copyright for all your creative works, and you can't accelerate the end of them. In German law, this is somewhat unclear. It's debated. If the work is clearly a copyrighted work, then the Creative Commons Zero license is very suitable for making it publicly accessible. But if actually what you're publishing is not copyright, the Creative Commons licenses are inapplicable. If it's not clearly copyright, what I suggest is that you attach a declaration saying this work was created automatically and is therefore not copyright. When your users see that, they'll be pretty confident that a court wouldn't award you a copyright that you haven't asked for, I'm pretty confident you couldn't effectively change your mind either. It's not going to, the courts aren't going to be very sympathetic if someone's done 10 years work based on it and you then say, actually, I now recall that I took a creative step that I'd previously forgotten. What if you've got some work that's not clearly copyright, but you want to restrict access? Well, if you want to offer access on specific terms to a work that's definitely copyrighted, then you can use a license. And 3 of the Creative Commons licenses do impose some restrictions. If it's not definitely copyright, then you're going to have a sequence of steps users go through before they get it, in the course of which they record their agreement to a contract with you. Another issue in a website is data provided by your users. It can be done several ways. You might upload some data for processing and get a response, and then the users may expect you to forget their data. The main guarantee they're looking for there is a guarantee of confidentiality. On the other hand, and that's one way that, for instance, the shape matching service could be used. On the other hand, you may accept uploads of data that join the database and enhance the value for everybody. The PDB has a third twist. You can upload data and say it will join the database in 3 months, but for the moment it's private. So all those require different terms and different forms of agreement. So if you're going to accept data from users, you need a clause something like the one on the slide, or more generally, you might simply require that your users apply the CC0 license to all the data that you accept. One license I know features a term: the depositor shall indemnify and defend the administrator from any claims by third parties related to any data submitted. Now, supposing I'd done some research in that domain, I wanted to submit, I'm not allowed to sign contracts on behalf of my institution, so I'd go to my legal department, they would read that and say no way. So I would suggest a couple of alternative ways of doing that. I think that in general it's appropriate for the provider of the service to say we will not hold you liable for claims by third parties against us relating to the data you provided. And if you can't see your way to saying that, you're not going to get many submissions. However, there is one condition I think is appropriately applied. That is that the depositor has acted in good faith. If someone's provided data to you as a piece of scientific fraud, where by research misconduct they fabricated the data, then I'd be pretty unwilling to accept any liability. So you'll see on this slide a way of expressing that the users have made good faith attempts to ensure that the data is accurate, and if they find out it's not accurate, they'll let the service provider know. So in what situations could you leave your web service unlicensed, just not do the legal thing? Well, in that case, you won't have any contract with your users, so you won't have any liability derived from a contract, and Irene soon will be explaining exactly what that means. But you can't give any guarantees. You can't promise them that their data they submit for processing is confidential. You can't make any promise about quality of service. If you do any of those things, you're creating a contract and therefore acquiring contractual liability. You can't say that, ask your users to agree that they won't submit 100 requests a second, but you could throttle them by technical means. All this might be acceptable for research purposes. I know some bioinformatics databases that are issued in this way, but as I've discussed, commercial users are not going to find this attractive. Now, there's another issue here. Suppose you intend to issue a license. On what basis can you later say this user has agreed to my license and it's applied to the use that was made? On the NIH databases, there's a registration process, but it's optional. I think that if there were a dispute, it would be quite hard to demonstrate that a user had assented to the terms of use for unregistered use. In fact, you and I know I didn't read the terms of use until I went to register, when I realised my use was not within their definition of light use. So the way that services force users to register assent is they issue an API key and only provide a service to request that contains an API key. YouTube search is an example of that. You can use it unregistered, but even your second request will receive an error response. So what rights might you want to give to your users? In regard to copyright, a clear award of the right to use the information in the responses. You might want to say including for commercial purposes. I've been in some commercial collaborations where there's data I can use for research purposes, but the commercial partner has to apply to use. It really makes life quite complicated. Most research activity nowadays is collaboration. If you don't have the right to transfer the data, then does your partner have to apply for it separately? Does that mean you can't share intermediate process results? It's better to give a clear right to transfer. The duty of attribution, as I've said, it's a clear academic norm, but there are situations when it becomes onerous. A number of people have written great papers where they've digested the whole PDB, they're not in a position to give an attribution to every author. They want to know that they're not in breach of copyright of the software that you've installed or the users who've contributed data. And so you increase the use of your service if you feel able to give a warranty over that. The PDB's license includes a statement that they give no warranty that use of the information does not infringe a patent. That seems sensible to me. Patent search is expensive and complicated, and so that expense should be suffered by the person who actually wants to use the data, not by the service provider. The software license for Java says that you can use this software for anything you want except for operating a nuclear power station. You can, in some situations, limit your a liability you would otherwise have had if you say, if you put in some exclusions for a bioinformatics service. Have you validated your results at a level at which, for example, you'd recommend to your sister terminating a pregnancy? In my experience, researchers tend not to think very hard about the safety implications of misuse of their research. If it's about software about structural stability, do you want someone running it to build a bridge? Now, Irene will talk more about this, but one of the options is to say the service is not available for those purposes. What about the server-side processing that occurs as people use your service? BioMedBridges is built by a list of scripts which they run once. The quality of the service very much depends on the correctness of those scripts, but they're not run continually. The shape matching service, the quality depends on some quite sophisticated software which is being under development now. There's a good scientific case for publishing your software when you publish your paper, and for the same reason that peer review is one of the best guarantees of quality. But actually there are some contradictory goals too. Server-side scripts often contain database password and file paths that you don't want to review. Some of the scripts for BioMedBridge use internal endpoints which aren't exposed, so other people couldn't run them even in principle. On the other hand, Bigr-XNAT have gone the route of saying, well, all our scripts as a package provide something valuable. A company could have an in-house clone of our database, or someone else could reuse our approach, perhaps with modifications for similar but slightly different data. Your users will want to know that in using your server-side processing, they're not violating the copyright of the people who issued the software. Note, by the way, that you can use GNU software, but if it's under the GNU IFRO license, some of the software that you've installed on the server, then you have to disclose modifications you've made to it, including linking other software with it. So here's an example. Here is the terms on which XNAT server-side software is available. Another issue with web services is derived services. You can create a lot of value by layering new web services on top of others, which they call. But on what terms would you like people to do that? If you've some colleagues of mine are about to buy a cluster to provide a X-ray structure solution service. It would be pretty inappropriate for a company to wrap up that free service in something they charge for. You might well want to exclude that. You might well want some credit. You need to require, for your own purposes, that any restrictions you have on direct use of your service are passed on by either technical or legal means to users of the derived service. So Chimera is a component of the shape matching software service which I mentioned, and here's a list of all the different data retrieval services and computational services that they use. It's substantial. So, in summary, in what situation do you actually need to issue terms of service? Well, one of them is if you discriminate between commercial users and academic users. One of them is if you want to warrant to your users that they don't need to fear copyright issues. One is if you want to warrant to your users that you'll keep their requests confidential. One is if you accept depositions of data, you have to at least have terms for your depositors, perhaps not only for your read-only users. If any of your data, I've been talking mostly about situations in which the data is wholly open. If you're handling any personal data about members of the Homo sapiens species, then clearly it's a different situation. And if you're providing significant processing resources, in the sense that keeping it going is onerous to you, then that's another situation in which you are going to need terms of service. The STFC has a draft license for web services, and here's an excerpt from it. The only point to make here is legal language is as technical as a computing language. This is not a job for geeks. You do need to speak to a lawyer who's qualified in the jurisdiction in which you're issuing the web service. A friend of mine recently asked me for advice about providing a web service in Finland, and all I could say is I hadn't the faintest idea. In addition, I'd like to thank several other people who contributed to a workshop at the EGI conference in Lisbon, which has informed this. And at this point, I'll hand over to my colleague Irene, who'll take us into the most scary part of this.
So, good afternoon, everybody, and thank you very much, Chris. So, I'm happy to talk the next minutes about limitation of liability clauses, since, as Chris has already mentioned, licensing could entail liability for the licensor. And this is exactly what researchers do not want while sharing their research results or offering web services. So let's turn to the first question. What exactly is liability? There's a basic definition saying that legal liability is the legally binding obligation to pay debts. That means a person is legally liable when he, she is financially and legally responsible for something, What does that mean in concrete terms? Legal liability can arise from various areas of law, such as contracts, tort judgments or settlements, even taxes or fines imposed by government agencies. So when we are talking about that you are legally liable for something, you are just the one who has to pay the debts. So the good news is many liabilities may be covered by insurances, but of course no insurance will pay for taxes. That's a field just for tort law. So for what actions, omissions can you be held liable in our context? In principle, any injury, that is breach of law, be it a general legal or a contractual obligation, can entail liability. So for us, that means an example for a contractual obligation is to deliver bad code or false information, false data on the basis of a contract. That would entail liability. And copyright infringements do not require any contractual relation to entail liability, but just the unjustified use of protected material of whomever. So who can hold you liable? That is anyone who has been harmed. This could be either the contracting party, if there is a contract for the breach of that contract, or any right holder. Coming back to the infringement of copyright, that is clearly the owner of the copyright. So is for example, negligence a prerequisite? Normally, yes, as long as we are talking about damages. No obligation to pay damages without fault is one of the principles in any legislation. There might be some exceptions in product liability, but let's just leave that aside. But, and this is important, liability for copyright infringements in relation to the copyright holder is not. There's no prerequisite to have committed negligence or something, because what you pay is not really damages, but a sort of license fee. You just pay that you have used something that you don't own. In Germany, it's even the normal license fee. In the United States, you have to pay double price just to show that you should have concluded a contract before. So a very important question in the academic community and the scientific community is, can you be held liable for scientific work? So there's a clear no for the mere publication of original scientific work. So any concerns you might have are unjustified. If you just act as a scientist and publish via a paper or even via the internet, then you cannot be held liable normally for that. I don't know any case where a scientist, for just saying, just sharing his scientific results, have been held liable. But maybe you can, of course, held liable for publishing information you are maybe by contract obliged to hold secret. For example, any pharma industry would not be happy if you publish the research results that you have found while working for the pharma industry, because they want to sell it. Maybe you can be held liable for scientific advice to governments if this is your task. There's one case of an Italian scientific institute that had the public task to warn before earthquakes, and they failed because they didn't observe the normal scientific standards, and they were held liable, but this is controversial. You are, of course, regularly liable for rendering scientific services on the basis of a contract. That is the normal thing for legal experts, lawyers who give an expertise on a certain case, and this is clear for clinical research organizations and others who make a living out of scientific expertise. So there's one case, the famous Duke case, that has raised some concerns in the scientific community. Therefore, allow me just a few remarks on this case. Duke University has been sued after clinical trials based on research misconduct. But I would like to emphasize that this claim has been based not on the bad science as such, but on the treatment of the patients. So that was the reason for the court to let the acknowledge the liability of the university and the university hospital, because they treated patients despite of the fact that they knew that the science based on it was, let's say, bad science, whatever that means. Based on false data. So, to our question here, can granting an open license cause liability? In principle, yes. Sorry for that. Licensing is, in a way, a contract. It contains a sort of promise. If you license something, you grant somebody else the right to use it. So, be it without or with payment, licensing can entail liability. And this is especially so if you infringe the copyright of others by licensing what you don't own. So it's quite important, and I'll come back to it later in my summarizing recommendations, that you make sure that you do not use, let's say, code or any other material of others and in your own work and then license the whole thing. So how can you limit the liability? There are limitation of liability clauses. They attempt to limit, define, or eliminate damages or compensation occasioned by parties, one of the parties conduct or breach of a contract. So important is that, of course, you can only limit liability in relation to the contracting party. So a limitation of liability clause is an integral part of a contract you conclude with somebody. You cannot limit the liability towards every third party you've never been in contact with. There are some, next slide please. There are some legal limits of liability limitation. And these limits exist in every legal system I know. So in general, to be enforceable, all limitations of liability need to be clear and unambiguous. This leads to the question if quite wide and general clauses are valid. So one example is a very common clause is to limit the liability to the fullest extent permitted by law to avoid uncertainty for the user. This is obviously valid under US law, but it's clearly void under German law. Under German law, there's the understanding that this constitutes an unfair passing of the risk onto the other contracting party. So you have to find the legal limits yourself. You're not permitted to just use that very general clause. In any legislations, there are some unfair contract terms legislations. So there are some common principles. There's a principle of fairness. There's a principle not to use surprising clauses. And of course, everywhere in the world, you are not able to limit the liability for intentional torts, because that would be too easy to limit the liability then and do what you want afterwards. I would now very shortly draw your attention to another term frequently used in the context of liability. Chris has already mentioned, and this is indemnity. A quite big difference is that it is the recipient that who indemnifies the provider against third-party claims. So don't mix up indemnity and liability. This can be the case, for example, if someone, when you are a data provider via a web service, and somebody sues you because personal data might have been disclosed unjustified, then you have a justified interest that the data provider helps you indemnified, let's say. So as Chris mentioned, it's quite harsh clause, but in some cases, maybe regarding human data, personal data, it might be justified to use such a clause. So I choose here one limitation of liability clause, including indemnity. It's just an example. It's not a concrete recommendation, because it's really hard to find a wording that is valid under any or all legislations in the world. So you always have to choose one, and you have to scan several examples and come to a very personal decision. What I like in this clause is that it refers to the principle of fairness, that both parties are equally obligated with this limitation of liability and indemnity clause. So I would like to come to some concluding recommendations. The first thing that is really important in my view is that you have to make sure that you don't infringe copyrights of others. So don't license what is not yours to license. So check all the code and data resources you have used to develop your own tool and your own service. And the second thing is, and this is open for discussion, is, in my personal view, you should even consider if you need to license at all, or just publish what you have without adding a certain license. Because, as I stated earlier, licensing ever entails liability in one or the other form. A really important, and Chris has mentioned this, a really important recommendation is any contract, including open licenses, should be granted not by the scientist as the legally responsible person, but the institution he or she is working for. It forms part of your work, and it should be the institution or university you're working for who concludes any agreement, any contract, including licenses. And this gives you the opportunity to involve your legal department that should check the license and liability limitation clause and take responsibility for it. Thank you very much.